Hi everyone, and welcome back to the next episode of our X-Files podcast. Today we are going to be going back to basics and talking about the divorce process from start to finish. As ever, it's me, Lucy Compton, senior paralegal in the family team, joined by my colleague Peter Lowe, who's the senior partner in our team. I think we thought we'd start kind of a bit of a mini series about going back to basics and some of the foundations of family law and sort of how you go about getting divorced, how you deal with your finances, all that kind of stuff. I think there's a lot of information out there online, and I don't always think that a lot of it is particularly helpful. So I thought we could start this little series by taking it right back and looking at just the divorce process today. So I think I'll start by saying that no one reaches the decision to get divorced quickly. It's something that happens over a very long period of time, and it's important that people know the ramifications of getting divorced, of making that step, and that they seek the appropriate advice when they come to make that decision. I think Peter's going to explain a bit about the some of the basis of how you can get divorced now since the law changed in April 2022.
Yeah, thanks, Lucy. And lovely introduction, because there are a lot of barroom lawyers and misinformation that's out there, and that hopefully this series is going to give people some foundation on which they can build their thoughts and ideas as to what's right for them. Divorce, as you say, it takes a long time sometimes to get around to and to understand when you want to go ahead with it. But there are some basic legal principles as well that might have an impact on that. A lot of people don't know, for example, that a divorce can only be applied for if you've been married for 1 calendar year. Something that comes across frequently if people have regretted getting married very quickly, if they've woken up in a Las Vegas hotel and found that it wasn't right for them. There does have to be a year before the application can be made to the court. There also has to be confirmation that the marriage has broken down irretrievably. It sounds simple, but very often people are unsure of that position. And to assert that to a court is an important step to take. And thirdly, we live in a world where people do get married all over the world. Weddings take place in different parts of every continent for very good reasons, sometimes for financial reasons, sometimes because of international relationships. But you would have to be able to show that the marriage is recognised in England and Wales. And with this international nature of relationships and marriages take place overseas, this is quite an important check to actually make. So, there are some preconditions before you can issue an application for a divorce. But from then on, the process has been quite simplified, I think, since last April. It was April 2 years ago now, as Lucy mentioned, with a kind of no-fault basis to that. Lucy, do you want to just explain, because I know that you do a lot of this kind of thing through the government portal that now exists.
Yeah, so now it's been for a couple of years that all applications for divorce must be made online. You can do it jointly with your spouse, or you can do it as a sole application just by going online and doing it yourself. It's become relatively straightforward, I would say. Before it was quite convoluted, whereas now it's very nice and simple. And I think aside from the requirements you've set out, there is a requirement to upload your marriage certificate. And I think that's probably as complicated as it gets in terms of the actual application.
I mean, the marriage certificate is an interesting one, because sometimes people simply can't find it.
Yes.
And have difficulty with one party having it. But, we can usually get around that by getting a certified copy from someone.
Yes. Yeah, there are definitely ways around that. So, and I think that's an important thing to mention, because I think a lot of people are very concerned when they come to see us and they think, well, I haven't got it. How do I start this process without it? There are ways that we can sort that, and it's very easy for us to get a copy of that in most instances. I think as well, what a lot of people don't know is that the court charge a fee for issuing a divorce application. And I think it's really important that people know that at the outset. And the current fee, I think it's due to go up soon, but the current fee at the moment is £593, which is a very unusual figure. But that is the current rate payable to deal with that. Once you've lodged your divorce application with the court, there is a period of 20 weeks that you must wait from the date of issue before you can apply for your conditional order of divorce. This used to be called the decree nisi, but now it's called the conditional order. This essentially just says that, yes, you're entitled to have a divorce, and after that has been pronounced, you must then wait a period of 6 weeks and a day before you can apply for the final order of divorce. And I think there are some important ramifications as well when it comes to applying for the final order of divorce.
Yeah, Liz, I think there's the romantics in us say there's a great shame that decree nisi and decrees absolutis terms are not being used anymore. People will often still hear that from friends or from people who've been through a divorce before the law was changed, that why aren't they getting a decree nisi, or why they're not getting a decree absolute? Well, they simply don't exist any longer. And even on programmes such as EastEnders or Coronation Street, people may still refer by the wrong terms. So I think, as you say, conditional order, halfway stage, certification that you're entitled to it, final order is when it comes to an end. And in theory, the new process said that this could be completed within 28 weeks. But I think the current reality as to the way the courts are, people can expect that it'll take 8 to 10 months for that all to complete. I think a couple should always be mindful that a final order, when the marriage comes to an end, it sounds obvious, but it's not always obvious, changes a legal status. So, for example, somebody may change in the event of their partner dying from the legal status of not being being a wife, then not being a wife. That means they're no longer a widow if that person was to die, which means they're no longer automatically entitled to benefits under a widow's pension. So it's always sensible, if you can, to wait until a financial settlement is in place before a final order is made, or at least take advice in relation to that part of it, because the two are interlinked. The court can't make a financial order until you've got halfway through to the conditional order, but bringing your legal status as a spouse to an end before you've got finances in place can have some tricky implications.
I think we say it day in, day out that it's so incredibly important to have your finances resolved before you walk away from anything. It is such an important aspect, and they need to be considered and thought about incredibly carefully. And I think we'll do another podcast about how we sort out finances, but I think you're going to explain a little bit about sort of the importance of sorting the finances out.
Yeah, I mean, we touched on this at our last podcast, and the statistics on the number of people who don't finalise their finances, even though they go through a divorce, there's a lot of people who don't do that. And the reason for that is that just because you're going through a divorce and your marriage comes to an end, it doesn't mean that your financial obligations come to an end. Finance is always considered separately, and they will not be dealt with unless there's a specific request made to the court, either where there's a dispute, or alternatively where there's an agreement and you ask the court to endorse that agreement. So it's always important to focus on that aspect as the divorce progresses. Whether it's divorce, civil partnership, however it is, separate out the family finances. Think about the provision that needs to be made for property, family home, savings, investments, pensions. Again, we've done 2 podcasts on pensions. Only 11% of people who go through a divorce have some form of pension share, which can't be right. It's got to be too low a figure. And income, and whether that's realistic as well. The circumstances for each couple are unique. There's no off-the-shelf answer to these things. And the guiding principle is that assets will need to be shared fairly, with first consideration being the needs of any children that you have. People don't appreciate not always clear that there's an established checklist of factors. The court have to, and we should, consider those factors. They're tied up in an act that's now nearly as old as I am, which is the 20... It's hard to believe, I know, Lucy, but that is true. From the Matrimonial Causes Act of 1973, it's an act that still wears flares, but it provides guidance on how to achieve a fair division of assets. You can have a look through it. The importance of each separate factor, whether it's standard of living, whether it's resources that the parties have, that all of those have been considered and interpreted for the last 50 years by the courts. And that allows the majority of people's finances to be settled by agreement, because couples have to give full disclosure. They need expert help to understand what that means, and then they can be advised by people who practice in this area of work, whether it's mediators, lawyers, sometimes arbitrators, all help to achieve a settlement.
And I think you've touched on it very well, but I think, using those people to really help you focus on reaching an agreement. I think it's important that people know that the majority of matters do settle outside of court, but it's not often that we need to go to court to have these matters decided. And I think it can be very daunting for people to think, they see it on television, they read about it, I don't want to be fighting in court. And more often than not, we're not fighting in court. I think it's important that people do approach those sort of alternative methods to resolving their disputes, such as mediation, arbitration, etc. It's only as a very, very last resort that we ask the court to get involved, like you say.
Yeah.
I think it's really important that people know that, and that people sort their finances before anything changes.
Yeah. As we said, this was a back to basics kind of starting point, and the basics should always be, how to approach the divorce, how the finances should be viewed. You give the opportunity to have the space and the time and the energy to look at those properly. You think about it both in the short term, but also long term as well, which is where a lot of these assets come to fruition, such as pensions. And as you say, it's not about anybody being on trial for anything or accused of anything. It's about achieving a fair outcome for the family involved. And the more that you can work at that, the easier it is to have a settlement that works for everyone. So we hope that this has provided some basic guidance from you. As ever, Lucy, I think if people needed further help, they can come and look at it from ourselves or from other sources.
Yeah, absolutely. If anyone needs any assistance whatsoever, you can give us a call on 01926 886688. You can drop our team an email directly and someone will get in touch with you, which is family@wrighthassall.co.uk. You can submit an inquiry through our website, or you can just pop in. We're more than happy to speak to anyone who's got any query. I think next week we're going to look at some back to basics in terms of the finances a little bit more. And I think that will be very interesting.